This is the most dangerous phase of these kinds of events. So everything looks mostly fine, right? Systems, they're still running, people still working, but you start to see the cracks.
I would encourage all parties at this point to ensure that the folks who need to be able to communicate about what is occurring are already starting to think about using and or already are using some form of out-of-band communications. The reason for that is your communications are going to be surveilled.
Based identity protection to make sure that you're enforcing that MFA. Incredibly important. I wouldn't tell you how many breaches it saves that have been on my desk.
You're having sensitive conversations, you are having privileged conversations through all these other channels with your clients. And there's just a knee-jerk, fallback to it that we see when we're talking about our own investigations and operations, where now we have a different consideration.
If you can't communicate, you can't remediate. And so you need a playbook for how those communications will take place.
You now pivot from the investigate to act. So Matt Welling, if we have staging files from relativity and deal E-rooms, how bad could this data really be?
In the interest of time, it's bad.
You're going to want to recognize and reduce some of your exposure to the MSSPs. This is very specific to the law firms. You're going to want to help, address dual compromise scenarios, both the firm and the provider. You're also going to want to, and this is for all parties, help practice your controls around preserving privilege under pressure, right? You're going to want to talk to counsel about this topic. You're going to want to understand what are the out-of-band communication patterns and what would be considered defensible record keeping, at least to the best of your ability to understand today.